Welcome up! In this episode we will be talking about constitutions and we will do a face-off between written and unwritten ones. Coming up. Hello, I'm Understanding Politics, and in this channel I explain political theories and debates to students as well as curious and passionate people, just like you. Firstly, what is a constitution? The Merriam-Webster dictionary defines it as the basic principles and laws of a nation, state, or social group that determine the powers and duties of the government and guarantee certain rights to the people in it. This definition well stresses an important point, which is a constitution is a system of beliefs, not a document. In fact, constitutions can be written or unwritten. Yet, I also have to warn you on the use of the word nation. This term has potential ideological implications, as there is no single state in the world with only a nationality inside its borders. As such, citizens of that particular state that do not identify with the nation that the state is supposedly representing may feel excluded and not represented by the country's constitution. Hence, it is more appropriate to talk about basic principle of a state, not of nations or social groups. At the same time, it is also true that the concept of constitution is ideological and reflects the beliefs of liberals who de facto invented the concept. If you watched my previous video on liberalism, you may be well aware of how liberalism emerged as a reaction to absolute monarchies, particularly in England and France, where the bourgeoisie or entrepreneurial class had troubles reconciling the interests of monarchs in levying taxes to justify wars and or in abusing their right to property and their right to safety. In such contexts, popular uprising paved the way for the creation of alternative forms of governments where the monarch was not the center of all power. This is when constitutions started being written. Basically, the constitution is a historical document that acts as a contract between all citizens of a particular country. This contract establishes all the basic rules and principles that citizens, institutions, and even regular laws had to follow to be considered legitimate. In a liberal country, there is nothing above the constitution, because there is nothing above the rules of the game. The first known constitution is the Magna Carta Libertatum, the document that granted British citizens their rights, an agreement that not even the monarch could violate. Liberal philosophers had been justifying the concept of constitutions for a while now, but they called it in a different way, the social contract. Thomas Hobbes introduced the concept of the social contract in his works to justify the need of an absolute monarch. John Locke, on the other hand, spoke of the social contract to argument the separation of powers. Finally, the most famous is probably Jean-Jacques Rousseau, whose book is in fact named The Social Contract, where the philosopher argued the need of an agreement that would create an institutional framework for the general will to exert power, based on the example of the ancient Athens direct democracy. All these philosophers presented the social contract as an intermediate passage between the state of nature, where people could do as they pleased, towards a society where people had to follow the rules of the contract and behaved in a civil way. The great problem with this line of argumentation is that there is no such thing as the state of nature. These three philosophers all tried to present an abstract argument not tied to history, but they failed. If you look at how each of them described the state of nature, you realize that they are just describing how people behaved at their time, in their country. You see, since the constitution is historical, it must reflect the times it was conceived in, to face the challenges that the society endured at that time. A simple example comes from the Italian Constitution of 1948. This document contains an article prescribing the illegality of fascist parties. Now, could people even think of writing such prescription if the fascist party never actually existed? The answer is clearly no. So, constitutions are not sacred and inviolable documents. They should be understood as historical milestones aiming at reflecting values and principles of a society at a specific historical moment. If some aspects of a constitution should no more reflect what those citizens think, then it is right to amend it. Clearly, this does not mean that the document should be rewritten from scratch. Now, we have written and unwritten constitutions. Although technically the only unwritten constitutions in the world are the ones of the UK, Israel and New Zealand. By convention, an unwritten constitution is not totally unwritten, but rather uncodified. It means that there is no clear synthetic document with all the rules. For example, the UK constitution is made of an ensemble of conventions, such as the Office of Prime Minister, treaties, precedents as case law, institutions such as the House of Commons, acts of parliament, and fundamental principles. So, scoring points. Which is better between written and unwritten constitutions? The biggest advantage of unwritten constitutions is that all the aforementioned documents and practices reflect the history of the country and the evolution of its conscience and awareness. Yet, it is also very confusing and very contradicting. Being a constitutionalist in the UK is a much more difficult task than being it in France. It might be that in the UK, all the institutions end up agreeing that a measure is constitutional, even if it contradicts recent decisions, because in the end there is no binding document. Still, if, and I stress if, political institutions achieve historical decisions and the society and courts agree, then change is much faster than in any country with a written constitution. The thing is, this does not really happen. On the other hand, countries with written constitutions need very wide majorities to approve amendments, and often need also the approval from the population through referenda. But flexibility is definitely an advantage, and the point goes to unwritten constitutions. A major disadvantage of unwritten constitutions is that there are several sources that can lead to different interpretations of the rules of the game. As a result, the powers of the executive, legislative, and judicial branches are not clearly defined, leading to ambiguity, uncertainty, and possible conflicts between the three pillars of government. This is not possible in a country with a written constitution. Clarity is definitely an advantage. Hence, the second point goes to written constitutions. The score settles in parity. There is no real winner in this contest. We may point out that most countries in the world have written constitutions, but this is not really a reason to prefer one over the other. Moreover, we must note how many authoritarian countries have written constitutions, and while they claim of respecting them, they deny the values at their core. In other words, you can have written documents and still violating them on a regular basis. The lecture is over. As usual, you will find the sources in the references section of the video description. Thank you for watching. Did you know that there is a great website called Constitute, where you can consult all constitutions of the world and their relevant changes over the years? Check it out.